I hope you enjoyed your lunch. We will now begin our lunchtime chat on building your career as an arbitrator. The panelists for this session are Ms. Christine Artero, independent arbitrator at the Arbitration Chambers, Professor Joongi Kim, professor of law at Yonsei Law School. Professor Kim is running a little bit late, but he'll be joining the session in just a few minutes. Mr. Christopher Lau, SC, chartered arbitrator at 3VB, Ms. Yoshimi Ohara, and Dr. Eun-Young Park. Moderating this discussion will be Ms. Elaine Wong. Thank you, Elaine. Please go ahead.
Thanks, Michelle. It's really great to be able to moderate this session with such a distinguished panel. I hope everyone had a really good session this morning. And today's lunchtime chat, I think, is just supposed to be a bit more of an informal forum to hear from some really experienced arbitration practitioners and arbitrators about how they went about pursuing their careers, how they got to where they are today. And I think everyone like me is really keen to hear from the panelists. I know that there's also a function whereby participants can send their questions through the Q&A tab. So please feel free to just type out your questions, send them to us. I'll try my very best to pick up on all the questions and pose them to the panelists, but please forgive me if I can't get everyone's questions in time. But let's kick things off. I think the first question in everyone's minds would be, why did you want to be an arbitrator? And what keeps you going as an arbitrator? So what motivates you apart from, of course, earning a living? Could I ask Christine to kick things off for us?
Thank you, Elaine. Hello, everybody. I think for me, why I became an arbitrator, so I think I just went full circle because it took me a while to get there, but I did. And so I studied law thinking I want to become a judge. Then when I reached the age back in France, meaning around 23-year-old, when I was about to go to the judge school, I thought I'm far too young to become a judge. So let's not do that and let's do something else. And so I went into private practice, and then that's how I also discovered arbitration, and I fell into arbitration. And then I think it just led me little by little, step by step through where I started, you know, and so that's how it came to for me. And what keeps me going, I think it's just variety. I love the variety of the cases, different subject matters, different issues, different lawyers, different co-arbitrators, different places, you know, where the travel is not something we're doing much at the moment, but you know, it's also part of it. And the autonomy and the independence of the job, that I wouldn't go back on that. That's me.
Thanks, Christine. I think that's really interesting to hear, because one of the questions that was sent by the participants prior to this lunchtime chat was, I guess people are curious to know whether we had a crystal clear goal to become an arbitrator. Was this always the plan? And did we build our careers according to direction, in accordance with that direction? Or was it something that, for example, the law firm that we worked at suggested that we might want to head down this path? So I think younger practitioners are curious to know how we arrived at the decision to specialize in this field and really pursue a career as an arbitrator.
Yeah. So for me, it didn't cross my mind the first few years. I didn't even think about it, didn't think I would want to become an arbitrator. And it's when I arrived in Singapore, so having worked in private practice in institution, and then I had to start all over again here. And I thought, what do I want to do? And then I think the idea started to come up, and then I started to consciously building my path towards, you know, becoming what I wanted to do, to become.
Yeah. So yours was a more organic decision. Like it was just the path that you took, and then realized at that stage of your career that that's how you wanted to focus things. But I think that's really interesting to hear. How about yourself, EY? What was your path like? Why did you want to be an arbitrator?
Yes, I started my career as a judge. I said in a bench for 3 years. I was young. While it was an honorable position, I was a bit difficult sitting in the bench all day listening the advocacies. I wanted to put my advocacies, but as a judge, your job is to listen to the advocacies. That made me rethink about my role, and I wanted to leave the bench, and I started to practice. When I left the bench, the president judge suggested that I should come back to the bench, and I promised him that once I have more experience and gray hair, I would come back to the judiciary. Now I have more gray hair, so I thought that I should go back to the bench. At that point, I was suggested to sit as an arbitrator. That actually was a solution to my problem because I still really like advocacies and persuasion that we do in arbitration. While I practice this arbitration, but still I can sit as an arbitrator. So that was kind of a solution for me to do the sitting as an arbitrator, doing adjudication, but at the same time, I still work on a lot of persuasion and advocacies myself. But being in an arbitrator role, I realized that I like adjudication very much. Probably that was kind of a trait that I learned as a judge a long time ago. So that's why I became an arbitrator, and also the reason why I like to be an arbitrator.
Thanks, EY. I mean, that's a very unique perspective, isn't it? I mean, not many of us can say that we started off being high court judges. And obviously, this is a skill set that has easily transferred onto your experience as an arbitrator. What I'm hearing is that you were sick of listening to other people's arguments and you wanted to have a more proactive role in the decision-making process. But that's really interesting. Thanks so much, EY. I think one of our other questions, I think people are just interested to know, I wonder whether I can address this question to Yoshimi. How did you get your first arbitrator appointment?
Thank you very much, Elaine. Well, I just briefly introduce myself. I started my career as a corporate lawyer and turned into dispute resolution lawyer, or slightly before that I did IP, and then turning into dispute resolution lawyer. So in relation to arbitration practice, I started to serve as counsel in international arbitration, which I found it fascinating. And then perhaps after a few years, since I started to do my arbitration practice, I was approached by, Japanese counsel, a couple of Japanese counsel who wanted me to appoint as co-arbitrator, but a co-arbitrator, party-appointed arbitrator. But most of the time I have to turn down because of conflict. My firm is a relatively large-sized firm in the standard of Japanese practice. So almost all the time, my prospective appointment never realized because I was almost always conflicted out. I think, if my memory serves, the very first appointment was made by arbitration institution when parties agreed to sole arbitrator, to have sole arbitrator, but parties unable to agree to sole arbitrator. So it is, I think this applies to many young arbitration practitioners. It's to build a good relation with the arbitration institutions and let them know that you are interested in being appointed as an arbitrator. That will open up the door for you to become. Thank you.
Yeah, I mean, I definitely agree with that, right? So I think we can see that there are many different paths by which people arrive at a career as an arbitrator, and there's no one-size-fits-all solution. But from my experience as well, I think very often if you act as counsel, so you know, in the beginning of your career, you're an associate, you become a partner, and you do a lot of arbitration cases. Obviously, you do get to know the arbitral institutions well, and they remember your good work. And then when there's an appointment, the arbitral institutions will go, oh, you know, so-and-so is someone that I think is suitable for this case. And that's very often how things start in terms of a career as an arbitrator. So I see that Jung has managed to join us, not to just throw you into the deep, but Jung, if you don't mind, can you just maybe tell the audience how you started off as an arbitrator? Why did you want to become an arbitrator? How you received your first appointment?
Thank you, Elaine. I'm sorry I joined late. I was at a prior meeting that I had to attend to. I wanted to add that, of course, I had the great honor and privilege of having Yoshimi as the chair of one of my tribunals. That was a great pleasure. I've been always interested in international dispute resolution. And I guess as that one thing came to another, and I started getting appointments, I guess, being in Northeast Asia, particularly, I find that there's not that many people so far. I'm sure given the immense talent that exists now, in 10 years, 15 years, there's going to be many, many, many more people. But when I was first starting out, there were not that many people, unfortunately. And I think I was just, as cliche as it sounds, at the right place at the right time. The first appointment that I got, the first appointment that I got that I can remember was an institutional appointment where the institution appointed all 3 arbitrators. And then I was appointed as a co-arbitrator in an ICC case. One of the counsel that I knew, who I had a professional relationship with, he appointed me. That's the first other non-institutional appointment that I can remember right now.
Does anybody want to talk about what it was like during the first appointment? Was there anything particularly challenging? You know, were there any barriers that you had to overcome, June, or maybe June or EY? Could elaborate.
EY, you want to go ahead?
Yeah. Well, I had served as a sole arbitrator and party arbitrator in Korean institution, but that has been a bit different from the international arbitration, because the way the domestic arbitration is run in Korea is somehow similar to the Korean litigation. So it's a progressive development. The big appointment for me from international institution was from the institution, but then I was appointed as a presiding arbitrator for the 2 cases together. So I had to learn the 2 methods together, but that case has been consolidated on the course of proceedings. But that was before we have very sophisticated consolidation rules of the institutions. So I had to work very closely with the parties, counsels, and the co-arbitrators to have these 2 methods consolidated. We did spend quite a time to have an agreement on the consolidation issues, and it was successful. So that was one big event I can remember. But that was, I think that one of the things I learned from that experience is that you have to exert a sufficient amount of discussion with your co-arbitrators, member of the tribunals, again and again, especially for a presiding arbitrator. You have exerted enormous amount of efforts to make things work. But that has been unfortunately successful, and I remember that experience as something quite remarkable, memorable. Thank you.
That's really helpful to hear. I mean, I can see there are a few questions from the audience, and I think young practitioners are interested to know how they start off. So, you know, are there smaller cases that they can be involved with? Somebody's asked whether there are pro bono matters in which they can act as arbitrators. I don't know if Christine, do you have any views on this? Oops, I think Christine's frame might have frozen, so maybe she hasn't heard me. Oops.
I'm back.
No worries. Yeah, so I guess people know that obviously once you have an established reputation, you can be appointed for very important cases and everyone gets that. But how do you start off small?
So yeah, I think it's people want you to have experience, but you need your first appointment to build up your experience. And I think we really have to commend the institutions for that, because the institutions are really the one giving younger people their first appointments and trying them, you know, in small cases. So I was saying just earlier that I don't think there is any type of pro bono arbitration case, but I mean, in my experience back a number of years, I used to work at the LCIA, and I know that it was very appreciated also. It's an hourly rate at the LCIA, so it was very appreciated that, you know, first-time arbitrators or young arbitrators would propose a very low hourly rate to you know, to try to work on very small cases. As Yoshimi was saying, it's important to make yourself known. It's important to build up your profile. Elaine, you were saying that institutions see your work as counsel, so they know you, they see your work, they see the way you draft, etc. But it's important to get out there as well. I think my first 5 years in private practice, I was just between the four walls of my office working head down, and I didn't realize there was a world out there, and I didn't realize that networking was important in arbitration, that you need to be out there, you need to make yourself known. Nobody will do it for you. So I think that's very important for young people to keep that in mind, work hard, have a very good quality of work, but also get out. Yeah, then in terms of first cases, there are the small cases. All the institutions have small cases, and they're very happy to give them to younger people.
Yeah, I definitely agree with that. The institutions are very supportive and help identify young talent.
Elaine, it's Christopher.
Yeah.
Can I add something?
Of course.
And it's this. You know, when you're a young lawyer, very often you act as counsel. My first arbitration appointment came because I had been standing counsel to two very large insurance companies. And there came a point in time when there was a huge dispute between the two of them. And because I was counsel to both, they came to me on an ad hoc arbitration to act as sole arbitrator. And I accepted that appointment. And this was, I think, something like 8 years into my career as a lawyer. So I think, you know, one way to get into arbitration, of course, is to be fully engaged in your work as counsel. And surprisingly, you may find that in the way you conduct a case, in the way you run a case, you engender confidence in the clients, in your ability, in your competence, and in your impartiality, to such an extent that both clients or some clients would be prepared to come to you to appoint you as an arbitrator, either party appointed or a sole arbitrator to decide disputes between two parties, both of whom are your clients.
Yeah, I mean, that's really invaluable advice for everyone. I mean, doing good work is really the best way of building your profile as an arbitrator, isn't it?
Oh, go ahead.
No. Go ahead,
Yeah,
please.
may I? Yes. One way young arbitration practitioner may build a career as an arbitrator would be to do the tribunal secretary. These days, a number of institutions have a formal process whereby tribunal secretary is appointed and the guidelines for the tribunal secretary. As a young arbitration practitioner, if you serve as a tribunal secretary, then you could know the way arbitration is conducted and also be familiar on the procedures. One of your job is to draw a lot of summary of the procedures and the procedural orders and things like that. So you could know about the procedural elements to it, which would be an important requirement as an arbitrator. So probably that's one of the way you could build up your expertise and knowledge as to the arbitration proceeding.
Yeah.
I could just add on to what EY has raised. As EY suggested, there are many institutions that have training programs to become a tribunal secretary. And I think also what I get contacted, I'm sure Christopher gets even more contacted much more frequently, but people just contact me out of the blue saying, you have any small cases or cases where you need a tribunal secretary? And of course, if I don't know the person, it's kind of difficult for me to invite them. But if it's someone I know or I have a good recommendation or I feel comfortable with, then, and if the parties, of course, agree, that's usually I will ask for party approval. Then I think that's also just keep on knocking on doors and show that you're available and willing. And I think those doors will start to open up as well.
Absolutely. If you're proactive and interested in being part of the community, I think doors will open, and there's no substitute for watching and participating in an actual arbitration and getting experience as a tribunal.
Well, and another way, Elaine, to do this, as we all know, moot courts, the Vis moot, for instance, in Hong Kong, in Vienna, the FDI moot, which has its finals in Korea this year, even though it's going to be virtual, would be an excellent way of getting yourself known. And you can join these moot courts to participate as an arbitrator or as a team leader of a moot team, because that is an excellent way of networking and also to show your interest in international arbitration. And I do know quite a number of people who, in participating in these moots, have been able to come onto the arbitration circuit as an arbitrator. So that's something worth considering, I think.
Yeah, absolutely. I mean, moving on to a slightly different topic, it seems like a lot of people are interested to know about the differences between litigation and arbitration. So, I think young practitioners are curious to know why one would pursue a career in litigation versus a career in arbitration. And I think the question on people's minds as well is it necessary to have a litigation background, or is it useful at all to have a litigation background before you become an arbitration counsel or arbitrator? I wonder whether, Christopher, did you have views on this?
Yes, I think having a litigation background is helpful because increasingly you find in international arbitration, it's become quite adversarial rather than inquisitorial. And by that, I mean the ability to cross-examine, the disclosure requirements, interrogatories. These are all very useful tools in international arbitration. So yes, I think it does help to have some litigation background.
Yeah, I mean, that's my personal experience as well. I started off in litigation at a time when arbitration wasn't this glamorous, sexy thing that we all know it to be.
Yes. But surprisingly, international litigation is also quite sexy.
Surprisingly. I know.
May I add a few points?
Yoshimi, please go ahead.
Yes, yes. Nowadays, we see more and more international arbitration cases, but they tend to be large case, and young arbitration practitioner doesn't have a big role to play in such big arbitration. But litigation could be a very small, and particularly like litigation in civil law jurisdiction. It can be managed by, senior associate, or one partner and one junior associate. And, through those experiences, young arbitration practitioner can build the capability of managing the case on his or her own. So litigation's experience is definitely helpful, but at the same time, everyone should be aware the differences of litigation practice and arbitration practice, and make sure that litigation practice will not be spilled over into arbitration practice. Another point of benefit of having international litigation practice is if you are involved in litigation in various jurisdictions like Europe or China or Latin America or United States, you can see the different legal background in those jurisdictions. And when you encounter counsel from those regions or parties from those regions, sometimes you understand why particular counsel takes a position in the course of arbitration. Sometimes they try to introduce local litigation practice, or intentionally, or just without intention, happen. They think that that litigation practice is a kind of universal practice, and by mistake, and then try to introduce as proceedings into arbitration. And having litigation experience overseas, particularly in multiple jurisdictions, that will help you understand opposing counsel's attitude or co-arbitrator's attitude, and you can find some optimal solutions.
If I may, Elaine.
Go ahead.
Yes, certainly I agree with what the Yoshimi and Christopher has mentioned. Litigation background is helpful. Having said that, there's some, downside or disadvantages to, put too much of litigation experience in arbitration. Because arbitration, because of its history and the background, the process is much more consensual than the confrontational compared to litigation. So if litigators are attending hearing and keep raising objection, then normally experienced arbitrator will not appreciate that very much. Even though a certain objection is raised in the arbitration, but the manner objection is addressed at the hearing is somehow different from the scene that you see in the courtroom. So for that matter, I guess that the skill set is helpful. Nevertheless, you cannot just simply transplant litigation background into the arbitration forum. Overall, I believe arbitration is a hybrid between contract and litigation, because the dispute that we're dealing with is not a mass tort actions or class actions. It is arising out of contractual disputes. That's why I guess a number of arbitration lawyers are from the transaction background, and they understand transactions like M&As, or distributorships, joint ventures, and they naturally understand the nature of the disputes. But at the same time, you need some litigation method to resolve these issues. These days, it's more and more so. So I think that the best combination would be that good understanding of the contractual structure, but at the same time, you apply the litigation tactics in a bit more softer manner. I guess that would be the best combination of arbitration lawyer and as an arbitrator.
Yeah, absolutely. I mean, it has to be a balance, doesn't it?
Yes, and I was, if I may, Elaine, agreeing entirely, of course, with what EY has said. For those who are looking at, who are at the moment in litigation, I can say that, that two practice areas where you can get very quickly international exposure. One is in maritime, the other is in intellectual property. I mean, as a very young lawyer, I was instructed, and Christine might know the company, by Yves Saint Laurent on trademark infringement of their famous Poisson perfume. And that required me to engage with lawyers in Taiwan, Thailand, United Arab Emirates, the UK, New York, and in Grasse in France. And that was a fantastic exposure, both civil, European, American, Asian, and UK, as well as, of course, Singapore and Malaysia. In doing this, you acquire enormous knowledge of the different processes in each of these jurisdictions, which is what arbitration is as well. Maritime is the same.
Yeah, I mean, that's really sage advice. Thanks, Christopher. Another question from the floor. How do you distinguish yourself from others when you want to be appointed as an arbitrator, or even if you want to act as counsel? What is effective or what works well as a distinguishing factor? You? Can I pose this question to you?
Okay, I think you're referring to me. General advice I always give to people, and this is probably a curse of my profession, but I recommend people to write. So the more you write, I think, particularly in in areas like arbitration, I think also to a large extent antitrust, there's a strong academic bent to, I think, arbitration practice. And if you are published in a particular area, whatever it is within arbitration, I think that's something that you can clearly distinguish yourself from the others. And there are people that, of course, are very exceptional in doing this, that are able to do both in very exceptional ways. So they set the bar really high for us.
I mean, it's an integral skill, isn't it, to be able to write clearly and express your views in a persuasive manner. So obviously,
and it shows your dedication and your specialty, your passion. People talk about it a lot. Oh, I really want to do all these things, but the proof is in the paper. If you've published, that really shows dedication. You've really focused. You're specialized in a particular area, and you can put that on your resume. You can send that to clients. It's a great way to publicize yourself, and I think you can easily distinguish yourself very quickly that way.
Yeah. All right. Thanks, Joongi. How about Christine? Any tips on how you might be able to set yourself apart from everybody else?
I don't want to sound pessimistic, but I think today it's more and more competitive, and I feel it's really much harder than it was like 15 years ago. And I remember we used to say, speak languages, for instance. But today, people tend to speak all kinds of languages, and or get qualifications, so get civil common qualifications, for instance. It's important. It gives you both backgrounds. So those are, I think, still good advice, but I think more and more people have that. Then we go back to the quality of your work. Just work hard but I think also if you set your goals, if you know where you want to go, if you know what you want to do, and just keep it in mind while you do things, then if you're passionate about something, it will show, and it will really help your career.
Thanks,
and
Christine.
Elaine, if I'm building on what Joongi said and what Christine said earlier, when you write well, you will be recognized by organizers of conferences, of arbitration conferences. And they will then invite you to be a speaker at these conferences. And when you're a speaker at these conferences, that is when you get known. So marrying the two, attending conferences and writing well, will result in you being invited to these conferences, getting known, and on that basis, coming into the world of arbitration.
Yes, we go back to put yourself out there, you know?
Yes. No point just slaving away in the four corners of your room.
I think, may I, Elaine?
Oh, yes, of course you are. Please go ahead.
I think that the reputation really matters, and reputation is built up not on a day, it's long time process, I believe. I had one occasion I was appointed as a presiding arbitrator on a Southeast Asia case. Interestingly, the Southeast Asia case was arbitrated between two local parties, but the size is so big and they determined to appoint all foreign arbitrators. There were English arbitrator as well as Australian arbitrator, and they appointed me as a presiding arbitrator. One of the, I think that among other things, one arbitrator had experience with me, I think 15 years ago that I worked with. So he had a good experience with me as a co-counsel. Another arbitrator who suggested me to become a presiding arbitrator was because of my speech at the conference. So if you build such a recognition and reputation among your peer, either as a co-counsel or colleagues or panelists, I think that those would be a good starting point for you to be recognized as an arbitrator or others in the arbitration community.
Thanks, EY. That's really helpful. Well, I've got a question that I think Yoshimi could answer. Are there any tips for transactional lawyers who are looking to make the transition to arbitration? So someone who doesn't have a litigation background or has a very little experience in litigation, how do you make that leap from being a transactional lawyer to an arbitration specialist?
Okay. In my case, it was an organic change. You know, it's not me who chose to change my practice area, but my client wanted me to handle disputes under the contract that we assisted with. So even if you start as a lawyer, start as a corporate lawyer, transactional lawyer, sometimes, unfortunately, parties to the contract enter into disputes, and that is the time you can assist because you are involved in contract drafting or negotiation. You know what happened when parties agree to the contract. So you can, you know, of course, work together with arbitration practitioner, and through working together with arbitration practitioner, if you really, you know, want to enter into arbitration practice area, that is the time you know, start to switch your, you know, destination. And because you have a good transactional lawyer background, that would definitely help you to be a good arbitrator in that, in relation to transactions. Because talking about my own experience, because I have been involved in, you know, IP licensing and M&A and joint venture, when you, you know, encounter disputes, you can immediately point out where is a flaw in the contract, why, you know, parties happen to agree to this particular terms. You pick out the point, and then that kind of insight or observation cannot be obtained by those who have been in arbitration practice from the beginning. You know, of course, they may happen to encounter similar situation, but having been a transactional lawyer, you can relatively easily pick up issues in the contract. So certainly your experience as a transactional lawyer would help you build arbitration career. Then perhaps the best way is to wait for one of the contract, unfortunately turn into dispute.
You can always rely on your corporate colleagues to perhaps feed you some tricky issues. Right. I'm joking, of course. Another question I think the audience had, Christine, I think new practitioners want to know, how do I get a chance to network with senior practitioners? How do I get to know people in the arbitration community? Do you recommend any particular events, courses that they should join?
So there are many things you can do, I think. And even if you're young students, even if you don't have a lot of money, you don't have to pay a fortune to go to all these events. Lots of them are free. So just pick all the free ones and get educated, go there, meet people, network. Courses, I think the CR courses are very good. You get lots of different stages and you can learn a lot about arbitration, and they're excellent. There are plenty of courses out there. And also meeting people. I'm turning to Christopher here. I remember when I arrived in Singapore 7-8 years ago, I didn't know anybody in Singapore. And I did want to meet great arbitrators. And so I just picked up the phone and, introduced myself to Christopher. And he agreed to meet straight away, and we had coffee. And you would be surprised that actually there are lots of very nice people out there doing that. And you shouldn't hesitate, just send an email, a nice polite email, explain the situation, explain why or what and people will meet you. So that was actually a great surprise for me when I arrived in Singapore, because I had all my network back in France and in England, where I had worked all the years before. And arriving in Asia, I didn't know anyone, and it was actually quite easy to get introduced into this arbitration community. So, but again, you need to take the lead. You need to take the lead.
Yeah. I mean, if you don't try, you don't get, right? And
exactly.
Actually, a lot of people are very generous with their time, yes. And I think more senior practitioners are also flattered that the younger people want to learn from them, and a lot of people have a very nurturing bent, and they want to help someone who's going through the same thing that they went through maybe 5-10 years ago. So I think just try a lot, and if the person doesn't respond or doesn't have time, I mean, what do you have to lose?
Absolutely.
Not a big deal.
May I add?
Yoshimi, please.
Yes. The beauty of this arbitration community is its collegial nature and cross-border, I would say cross-border collegial nature. Like at the time when I started my arbitration practice, there are a few resources available in Japan in relation to international arbitration. So essentially learn arbitration practice from my colleagues or senior arbitrators outside Japan. And they are quite, helpful, lend hands to a person like myself, not really experienced in international arbitration. So if you reach out anyone in this field, and particularly a high-profile person, they will definitely assist you. And there are a number of communities for young practitioners to build that kind of relationship, like mentorship program. I'm a governing board member of ICA, and ICA also provide young ICA mentoring program. It's not easy to get into, but once you get into, you can have a good mentor and help you build your path in this arbitration community. Thank you.
Thanks, Yoshimi. Joongi, what do you think? Do you think there are any specific qualifications or certifications that someone should pursue in order to really get ahead in this field? Or is it a more informal process? What do you think is really important as a quality or certification for an arbitrator?
Well, I think just to echo everything my colleagues have been talking about, you know, the simplest thing, of course, is getting like a certification or a fellowship from like the Chartered Institute of Arbitrators. They have similar things in Singapore and Hong Kong and many leading jurisdictions. I think that definitely is something you should, younger practitioners should think about and explore. Getting those titles, showing that you've done the training, and meeting people, the people that will be teaching those programs, the people that you will be learning together with. That's a great way to network. I'd like to add that as, particularly as on building on what Yoshimi suggested, it is a very, very, very collegial community. And I don't think, and it's incredible if you think about it, you have this global collegial, and of course some would say it's a mafia, but it's a very collegial community, and everyone is very, very open and very nurturing. And don't be shy. Don't be shy. I know there are a lot of people that are interested, you know, like, oh, I'm just a lowly, you know, first year, second year. Well, how can I introduce myself? No, you should. And, you know, if you're a senior person, I've met some of the most senior, when I was first getting into this field, I was like that myself, and I'd meet these big people that I had been reading about all my life, and I'd introduce myself, and they were the kind of the warmest and generous people that I've ever met, which made me even more impressive, because not only were they at the top of their field, but they were just so generous and open and willing to engage some lowly professor from Korea who didn't know what he was talking about. So I think that's just something you have to get over, and you can, anybody who puts their mind to it, can join the community if they have the passion and the dedication.
Yeah, I think lots of people are just attracted by young talent. People like engaging with someone who's enthusiastic and shows a deep interest and passion for what we do. I like the next question. I'm going to ask Christopher if he can answer the next question. So it's often said that being an arbitrator is a retirement job for a litigation practitioner. A, do you agree with this statement? B, is there an optimum stage in your career where you should make a start at being an arbitrator?
There is no particular stage. Sometimes it comes by chance. I mean, it did with me very early in my career when I was counsel. And as I said, 2 clients came to me to sit as an arbitrator to resolve a dispute which they had between themselves on what a particular insurance coverage meant, the scope of a particular insurance coverage. But I think, you know, the most important thing really is as EY said, and all the other colleagues have said, it's expressing and showing a commitment to arbitration, letting others know you are interested in getting into this practice, that you're prepared to contribute positively to it, and keeping at it, and not you know, giving up. And you know, Joongi referred to the mafia. Don't let that put anyone off, because mafia essentially stands for Mutual Assistance for International Arbitrators. It's actually a very friendly term.
I was going to say it was a brotherhood or a sisterhood, but I think that's good.
It's Mutual Assistance for International Arbitrators.
Oh, yes. EY is back as well. Hi, EY.
Yeah, I'm sorry. Yes, I'm back. Sorry that I couldn't show my face because I am in a car. So actually the screen is constantly moving. So I just wanted to put my field code rather than constantly moving screen. Just to follow up on the Christopher has mentioned. yes, it is very collegial community. Nevertheless, I guess that the fundamental of the legitimacy arbitration is independence and impartiality. And each individual arbitrators or arbitration lawyers maintain highest degree of integrity, and they know that they are checked by others. That's why they are so obsessed as to the conflict of interests and disclosures. I think that one of the most important elements would be to maintain a fairness. The arbitrator maintain a fairness to the parties' counsel as long as amongst the arbitrators themselves. That is why I believe that it survives, even though we have such a close related relationship, but it is not without a check. Thank you.
Oh, absolutely,
Yes.
absolutely.
No,
Because
EY
you
is
want to make
absolutely-
sure that your reputation is maintained within the close-knit community.
Yes, I mean, EY is absolutely right. It's a very small world. And if you misbehave or you misconduct yourself, word gets out very quickly. You can build, it takes a long time to build up a reputation, but one bad act will destroy it for you. So you do have to be very, you do have to be very, very careful.
Yeah, wise words. Christine, could I ask you, at what stage of your career did you consider it ideal for you to become a full-time arbitrator? So, what did you consider, or what did you take into account at that stage when you wanted to make that leap?
Well, first, I did not take into account what EY referred to, my gray hair, because I do not have that many.
I share your pain.
I'm not sure there is an ideal age to become a full-time arbitrator, to transition to be an arbitrator. I stayed in private practice, and then at some point I decided to move on to do something else, to go and have their own practice as independent arbitrator. For me, I mentioned earlier, I think it was a bit different, and so I became a full-time arbitrator at quite a young age, I think, compared to other people. But I see more and more people doing it actually around me in the community, not only in Asia but in Europe as well. And as we discussed, I mean, for me, it became natural because I had, after about 12, 13 years doing exclusively arbitration, I had acquired like the perspective of the different perspective in arbitration. So from private practice, from institution, from tribunal secretary, I had done some teaching in arbitration, and building all that together, it became quite natural for me to transition to become a full-time arbitrator. And also because my workload had just built up more and more, so that I didn't have much time to focus on other work such as tribunal secretary work or other things. So yeah, for me it was just natural, and I don't think there is a typical moment or age where you should or should not do that. Yeah.
Thanks, Christine. Well, I have another interesting question. I think the audience wants to hear our war stories. So, Joongi, do you have any real life concrete examples of someone who did something, obviously not any of us on this panel, that harmed that person's reputation? So it's sort of just like a cautionary tale, something that young practitioners should keep in mind, like don't do this, that would probably have or cause some damage to your reputation as an arbitrator.
The way I like to answer this question is, if you are counsel, I think it's very, very important that you are perceived to be maintaining moral high ground. So meaning that you are acting in a trustworthy way and with integrity. If you do not leave this impression with the tribunal. And of course, this is something that has to come natural, and you have to be doing the right thing. But if you don't, some things will come up and you will not get the benefit of the doubt. And as we were talking about, your reputation will suffer the consequences. There are counsel that will conduct things, their case in a very sharp manner, and I would argue sometimes too sharp. And that over time, very quickly, will rub the tribunal the wrong way, and you will lose a lot of credibility. And even after that case, that tag, I think, will stick with you. And I don't think you want that type of a tag. Being aggressive, and I think there's a difference between sharp and being aggressive. You can be aggressive in a fair manner. You should be fervently advocating your client's position, that's fine. But being sharp and at the edges, I think that's really getting in very dangerous territory. Yeah.
It's a fine line to walk, isn't it? Yoshimi or Christopher, any examples that you've come across that you want to share with the audience?
Well, two. One lighthearted, the other one a bit more serious. The lighthearted one first. Sitting as a judge, I found that when I walked into the room, all counsel would stand up. Then when I was sitting as an arbitrator, when I walk into a room, the same counsel would sit down. So it's a different sort of respect. But on a more serious tone, I had one arbitration where just before I was due to arrive, a party had filed an application to stop me from sitting. But because the application had yet to be heard by the judge, I took the risk and I flew in and I heard the arbitration, and then and when the arbitration was over, my co-arbitrator said, if I were you, don't bother to do any sightseeing, get on the plane and get out fast, because the party who had taken out the application was about to get an order preventing me from sitting. The risk there, of course, was that I would have been jailed for contempt of court. So that is the more serious, the dark side sometimes of international arbitration.
Yeah, it's a shame, isn't it? Some people will resort to quite aggressive tactics instead of just trying to win the case on the merits.
Yes.
Well, Yoshimi?
Well, unfortunately, I do not have that kind of dramatic experience. So far, I have been treated properly and respectfully. Hope I wouldn't encounter that kind of, uncomfortable and potentially dangerous situation put forward by the party.
Yeah. We'll just count ourselves as lucky not to have been in that position. And I think maybe I just have time for one last question. I wonder, perhaps EY, if you're on the line, if you could address this question.
Yes.
So any advice for someone who's just starting out, as your first time as an arbitrator, you're on a panel of three, how do you deal with the fact that, you as an arbitrator, for example, you are actually maybe younger, more junior to counsel. Counsel could be a very experienced practitioner and could maybe be looking at you and thinking, what does this young person know? Why is this person deciding my case? Any tips for the struggles of young arbitrators?
I think that the age doesn't matter. As long as you have a strong principle as a decision maker, I think that you deserve all the respects and you are qualified to do so. I said as a judge when I was young, nevertheless, very experienced counsel appeared before me, highly respected me, not because of considering my age, but because I did my work pursuant to the principles. And I think that it relates to issue of when you become an arbitrator. I think that the time that you become arbitrator is when you have a big ear. Normally, as a counsel, you have a strong, powerful advocacy speeches. But if you start to have a powerful listening skill set, meaning that you have a big ear, I think that you're ready to become an arbitrator. Thank you.
Thanks, EY. And thank you everyone really for your participation. I've had a lot of fun. I mean, I've been on many panels, but I think for this one, everyone's been really engaged. We've received a load of questions, and I think all the panelists have really pulled together and tried to give their best answers and really tried to address all the concerns that everyone has had. So I'm really grateful for everyone's active participation, and it's been really fun. Thanks everyone.